Good morning, and the subcommittee will come to order.
We were told they should just stay.
Good to see you here. Today, the committee is resuming its hearing on reauthorization of the U.S. Patriot Act. As the panel today will testify, that is, if we had a stronger and better enforced Patriot Act, that plane would have never gotten this close, and we would have stopped it before it had taken off. Just kidding. But I appreciate the flexibility of this panel to come back. I apologize for the inconvenience, but as you're aware, nothing we could do about it. We were rushed out of the buildings or out on the streets as quickly as what you were. And there was no distinction between panelists, members of Congress, visitors, reporters, or anything else. We were all, one way or another, making our way down the streets in Washington, D.C. So thank you very much for your flexibility in being back here today. When we were interrupted, the committee had heard testimony from Deputy Attorney General James COMEY. General COMEY talked about why it is important to have a robust and reasoned discussion about the Patriot Act. He emphasized that it had been an earth-shattering law in destroying the wall between intelligence and law enforcement and terrorism investigations that had begun changing the culture of both professions to better protect our nation. The Patriot Act also provided many enhanced authorities, which he called smart, ordinary, reasonable, and constitutional to support intelligence and terrorism investigations. Many of those authorities are fundamentally intelligence authorities to counter threats to our national security from terrorism and espionage. I want to emphasize again that these are not intended as a license for the government to invade the privacy of ordinary citizens or to violate civil liberties. They are usually targeted against foreign powers and agents of foreign powers and not average American citizens. Deputy Attorney General COMEY also testified that we should have robust discussions and oversight of how those enhanced authorities are used. I agree. The intelligence committees are the only committees that receive detailed reporting on how the FISA authorities of the Patriot Act are used in practice. And there has been close and continuing oversight not only by this committee but by many other interested parties and the public. As part of that oversight process, the Department of Justice Inspector General reported earlier this year that it had received 1,943 allegations of abuse of the Patriot Act. None of those complaints were found to have even alleged misconduct by the Justice Department employees relating to the use of a provision in the Patriot Act, and only 12 warranted further investigation for civil liberties issues unrelated to the Patriot Act. This public hearing is also part of that process. Today, the committee will hear testimony from outside witnesses and experts. Professor VIET DINH, who was one of the architects of the Patriot Act while serving as Assistant Attorney General for Legal Policy. Professor Richard SEAMON will provide legal expertise. From advocacy groups, we will hear from James DEMPSEY of the Center for Democracy and Technology and Tim EDGAR from the American Civil Liberties Union. We look forward to your testimony and to the discussion. I'll now yield to Mr. Hastings for any opening statement he may wish to make.
Thank you, Mr. Chairman, and we thank our witnesses. I'm standing in for Ms. Harmon, who unavoidably is not with us this morning, but had she been here, her remarks would reflect that we welcome all of the witnesses and appreciate your willingness to return this week after the untimely evacuation of the Capitol Hill complex last Wednesday, as the chairman was just saying. Thank goodness it was only a false alarm, unlike the stark reality we faced on September 11, 2001. The horrible events of 9/11 and the subsequent anthrax scare sent Capitol Hill and the world into a tailspin. And it was against that chaotic backdrop that Congress considered the Patriot Act. The rush to pass the Patriot Act in the weeks following 9/11 resulted in Congress granting the government sweeping authorities without fully appreciating the impact of those authorities on civil liberties. In my opinion, some provisions were not carefully tailored to meet identified needs. As a result, the Patriot Act went further than what was needed to protect our homeland. Over the past 3.5 years, law-abiding citizens have raised concerns about the Patriot Act in town hall meetings across the United States, and they are concerned about potential government overreaching and abuse of civil liberties. Their concerns should be heard and not simply dismissed. And to the extent appropriate, Congress should change the law to address the valid concerns of those we represent. 16 Patriot Act provisions are scheduled to sunset in December. Of particular importance are a couple I hope our witnesses will address today. Many of us have concerns about Section 215, or this so-called library provision, allows the government to obtain records of any tangible item under the Foreign Surveillance Act. Legitimate concerns have been raised that the law, as currently drafted, gives the government a green light to go on fishing expeditions for library, bookstore, medical, or other sensitive personal records. Deputy Attorney General COMEY testified last week that the Department of Justice agrees Section 215 should be amended to include an express relevance standard and a provision allowing a person served with an order to obtain an attorney and challenge the order in court. The devil will, of course, be in the details, and that is why I look forward to hearing our panelists' views on proposed changes to 215 to help ensure it can't be interpreted as a license for a fishing expedition and to ensure a meaningful judicial review process is incorporated into the law. Second, I also look forward to your thoughts on Section 206, the John Doe roving wiretaps that allow surveillance when neither the identity nor the location of the target is known. This causes concern for several reasons. For one, it arguably could lead to the general surveillance of large numbers of people of particular ethnic backgrounds. I believe we should seriously consider aligning the intelligence roving wiretap standards with the criminal standards in Title III, and I hope our witnesses will share their thoughts on Section 206 and suggest modifications. As we consider reauthorization of the Patriot Act and consider the administration's new proposals to further expand government authorities, we must pay careful attention to striking the delicate balance between civil liberties and security. Mr. Chairman, according to media reports over the past couple of days, the Senate Intelligence Committee is considering marking up in closed session unclassified legislative provisions to expand Patriot Act and other government authorities. I hope that when this committee considers public legislation such as reauthorization of the Patriot Act, that it will do so in open session. With that, Mr. Chairman, I thank you, and gentlemen, I look forward to hearing your ideas on how we can make the necessary modification.
I'll not respond to how the other body is going to do their work in regards to marking up a Patriot Act or an extension of the Patriot Act. As is custom in this committee, we will do what is appropriate to do in public. Will be done in public, and those parts of a markup on the Patriot Act that need to be done in a classified section will be done in a classified section. I think we'll continue that tradition. You guys are seated in a little bit different order than I have here, but we'll just continue the tradition of the House, and we'll begin with Mr. SEAMON, and then we'll go to Mr. DEMPSEY, Mr. DINH, and Mr. EDGAR. All of your written statements will be submitted in their entirety for the record. So if you want to vary or stray from your written remarks, they will be on the record in their entirety. And we'll begin with you, Mr. SEAMON. Thank you for being here.
Thank you very much, Mr. Chairman, members of the committee. Thank you for the honor and opportunity to testify on reauthorization of the Patriot Act. I would like to make one main point, and it concerns Section 218 of the Act as interpreted by the Foreign Intelligence Surveillance Court of Review in its 2002 decision in re Sealed case. The Court of Review interpreted Section 2...
Can you pull the mic a little closer? We're not used to being in this big of a room, and
Yes, I'm gonna have to
the
apologize.
acoustics aren't that great, so thank you. The mic is turned on?
Yes, it is. I'd like to make one main point, and it concerns Section 218 of the Act as interpreted by the Foreign Intelligence Surveillance Court of Review in its 2002 decision in re Sealed case. The Court of Review interpreted Section 218 to bar the government from using FISA surveillance to get evidence to arrest and prosecute foreign agents for ordinary crimes, even if such arrests and prosecutions are necessary to prevent acts of international terrorism and the other foreign threats identified in FISA. That interpretation is wrong, and it puts a potentially serious restriction on the government's power to fight international terrorism. I urge Congress to amend FISA to correct the error and remove the restriction. Now I'd like to briefly explain how the Court of Review erred and how to correct the error. As amended by Section 218, FISA requires the government, when seeking a FISA warrant, to certify that a significant purpose of the proposed surveillance is to obtain foreign intelligence information. Foreign intelligence information is defined in relevant part to mean information that is necessary to the ability of the United States to protect against international terrorism and certain other foreign threats. Under this definition, if the best way to prevent a planned terrorist attack is to arrest the foreign agent involved in the planned attack, the evidence needed for that arrest is foreign intelligence information that the government should be able to use FISA surveillance to obtain. And that is true whether the evidence concerns an ordinary crime, such as overstaying a visa, or a foreign intelligence crime, such as espionage. And that is true for the same reason that the government was able to end the depredations of Al Capone by putting him away, not for the crimes that made him public enemy number one, but for not paying federal taxes. My basic submission is that FISA now and always has allowed the government to use FISA surveillance to take the Al Capone approach to fighting terrorism. The Court of Review and other federal courts, however, have failed to recognize that power. To clarify the power, FISA's definition of foreign intelligence information should be amended to specify that it includes information that is necessary to the ability of the United States by law enforcement means or other lawful means to protect against international terrorism and the other foreign threats identified in the existing definition. I thank the committee.
Thank you. Mr. Dempsey.
Mr. Chairman, members of the committee, good morning. Thank you for the opportunity to testify today. The issue before us is not whether the government should lose the Patriot Act powers. Of course, they should not sunset. Instead, the issue is what checks and balances should be added to the Act so that the government has the powers it needs to prevent terrorism, but those powers are subject to clear standards, judicial and legislative oversight, and some form of public accountability. No doubt, terrorism poses an urgent threat to our nation. The agencies that protect us have a difficult task and they pursue it diligently. But a framework of guidelines, standards, and rules will not prevent them from doing their job. In fact, that framework of rules, properly constructed, will make them more efficient and effective. Now, the government has argued that it should have the same powers, subject to the same standards, in intelligence investigations that it has in criminal investigations. But terrorism is a crime. So is conspiracy to commit terrorism, funding terrorism, and many acts preparatory to terrorism. If these criminal powers are so great, why doesn't the government always use them to investigate terrorism? The answer is that intelligence investigations are special in ways that make them preferable to the government but also in ways that make them more dangerous to liberty. First, intelligence investigations are broader than criminal investigations. They are not limited by the criminal code. Look at sections 215 and 214. They refer to an investigation to protect against international terrorism. Think of an investigation to protect against tax fraud, or an investigation to protect against bank robbery. How broad would that be? Intelligence investigations can investigate legal activity. They can collect information on First Amendment protected activity. They can focus solely on First Amendment activity. Also, intelligence investigations are conducted in much greater secrecy than criminal cases, even perpetual secrecy. When a person receives a grand jury subpoena, he can publicly complain about it. In criminal cases, even the target is often notified while the investigation is underway. Most searches in criminal cases are carried out with simultaneous notice to the target. The police come, knock on the door, open up, we have a warrant. Even though wiretaps in criminal cases are conducted in secret, the target is notified afterwards. Notice is an important element of the Fourth Amendment protections, but most searches and wiretaps and intelligence investigations are kept secret forever. Third, maybe most importantly, the big show in a criminal investigation is the trial. A prosecutor knows that at the end of the process, all of his actions, all of his activities will come out in public. If he was overreaching, if he went on a fishing expedition, that will all be aired, and he will be subject to criticism and even ridicule. That's a powerful constraint. But most intelligence investigations never result in a trial. The evidence is used clandestinely. Sometimes the desired result is the mere sense that the person is being watched by the government. So the question is, since intelligence investigations are broader, appropriately so, more secret, appropriately so, and there is less after-the-fact scrutiny, necessarily so, how do we build in protections at the beginning? That is where the Patriot Act falls short. Consider Section 215, the business records provision. Of course, the government should have access to business records in intelligence investigations. And the library issue, I think, is a little bit of a red herring. So let's not get too deep into that. But under Section 215, the particularity standard that used to be in the law, the agent of a foreign power standard, was eliminated and replaced with no particularity at all, only an assertion of relevance to a potentially undefined intelligence investigation. The judicial approval, which Mr. Comey stressed repeatedly last time, is not really serious. It's almost a question why it's there at all, since the judge is not presented with any factual information according to the words of the statute and has no discretion to turn down the request. And unless the target is actually charged with a crime and the records are used against him in trial, he is never notified that the records have been disclosed to the government, which means, ironically, that the innocent person, the person who was the victim of overreaching, can never complain because he never is told that his records have been obtained by the government. Now, let me make an important point. The application of 215 in practice, so far as we know, seems to have been narrower than the words of the statute would allow. And I think this is important. Mr. Comey said, for example, that there is in fact a particular person that the government is interested in. Not necessarily an agent of a foreign power, but someone connected to a suspected agent of a foreign power, a suspected spy or terrorist. Secondly, if you look at the FBI's now unclassified advice to the field on preparing Section 215 orders, it is clear that the application that they prepare internally for their own internal approval does in fact contain specific and articulable facts explaining why the records are being sought. That's not required under the statute. They're doing it. Mr. Comey kept stressing that under 215, the government application must be in writing. But if you look at 215 in contrast to other statutes, it never actually says in writing. I just think that's an oversight, a reflection of the haste in which it was drafted. But Mr. Comey offered up what I thought was a very good standard. Quote, meaningful, logical connection between the records sought and the subject of the investigation. What we're saying is write those standards into law. Mr. Comey is leaving government in a couple of weeks. Let's put that guidance, that standard, into the words of the Act to guide future Departments of Justice. Similar amendments are needed to other provisions of the Act that would preserve the authority. And while the law needs to keep pace with technology to ensure that the government has the tools that it needs, the effect of the Patriot Act in that regard is, I think, sometimes exaggerated. Under both FISA and the criminal wiretap law before the Patriot Act, the government could tap cell phones and computers. The laws had been technology neutral. They had been rendered technology neutral in '86 on the criminal side. FISA had always referred to electronic communications generally. But also, the law needs to keep pace with changes in technology to protect privacy. And a lot of the trends in technology in recent years have put more information at the government's disposal and made it easier, in fact, for the government to obtain information. And that half of the equation was ignored in the Patriot Act. I think some elements of the Patriot Act have been applied in a way that I would consider to be abusive, or certainly beyond what this committee and the Congress intended. The Justice Department recently submitted a report on the sneak and peek authority. They indicated that in one of the cases, not a terrorism case as far as I could tell, most of the sneak and peek authority is not limited to terrorism, and it's not a FISA authority. In one case, the notice there was delayed for 406 days. In 7 of the cases, the court approved the delay for the duration of the investigation. Now, I don't think that that is the kind of care and specificity and control that Congress thought it was creating when it created the sneak and peek authority or codified it. I don't think that 406 days is what the prior case law had anticipated. Now, Mr. Chairman, we're eager to work with you and the other members of the committee and the Congress to try to find these checks and balances. Undoubtedly, these are extraordinary powers. They respond to extraordinary circumstances, but extraordinary powers need special protections, and that should be the exercise of this committee and of the Congress as we move forward to ensure that the government continues to have these powers, but subject to checks and balances in a way that the public can trust and that all members of Congress can trust. Thank you, Mr. Chairman.
Thank you very much. Mr. Den.
Thank you very much, Mr. Chairman. Thank you very much for convening this meeting, this hearing, and not only for having this hearing, but for the important work you've done in this committee for the last 4 years. The provisions of the Patriot Act, over which this committee had oversight for the last 4 years and had substantial input in drafting, are by far the most significant and critical changes in law, in the USA Patriot Act, and in the way we do intelligence and criminal law enforcement in this country for the last 4 years. It is not an understatement. Rather, it is an obvious fact that the success that our country has enjoyed in the last 4 years in preventing another terrorist attack, where not another American life has been lost in the last 4 years, owes a great debt to the work of this committee and its staff. For that, I thank you, and I think the American people all owe all of this committee and its staff a great debt of gratitude. The information sharing provisions of the USA Patriot Act, over which this committee has jurisdiction, here I'm talking about Section 203, 218, and 905 of the USA Patriot Act, as Deputy Attorney General COMEY said last week, were critical in bringing down terrorist cells and continuing to prevent terrorist conspiracies here in the United States and abroad, because it broke down that metaphorical wall between intelligence and criminal law enforcement. Critical, necessary as these provisions were and continue to be, they are not sufficient. They only begin the process through which culture change must happen in our criminal justice system and in the intelligence community in order to effectuate the vision that this committee sought to put into law and to authorize through these provisions. That culture change is yet to happen. I think the 9/11 Commission has noticed this, but more importantly, the Silverman-Robb Commission into the WMD mishandling noticed this and recommended specific changes in order to effectuate the vision of this committee and of the Congress in authorizing the information sharing integration of sections 203, 905, and 218. Specifically, I think that Judge Silverman and Senator Robb and their commission is completely correct in recommending the creation of a national security division within the FBI that gives enhanced authority to what is currently the Directorate of Intelligence to include not only the existing Office of Intelligence, but also the Counterterrorism and Counterintelligence divisions of the FBI, creating within the FBI one half which is devoted to criminal justice enforcement and one half which is devoted to national security matters, including counterintelligence and counterterrorism. I think the establishment of the Office of Intelligence and then its supplanting with the Director of Intelligence is a good first step. However, the underlying cultural change in order to collect criminal and terrorist intelligence information and analyze it and go back to the field to validate that intelligence and the assets giving up those intelligence cannot happen unless the Director of Intelligence has authority over the field operations of the Counterintelligence and Counterterrorism divisions. Likewise, the lawyers currently in the National Security Law Unit headed by Spike Bowman are probably the most knowledgeable lawyers about the operation of intelligence and the restraints of law. I think they should be empowered to work within this National Security Division in order to ensure that all laws are met and all activities permitted by law are taken in order to protect and prevent terrorism and counterintelligence activities. Likewise, the Robb Silverman Commission recommended a number of changes within the Department of Justice in order to mirror the changes it recommends in the FBI. I think these changes also are critical in the reorganization of our criminal justice system and our intelligence to make sure we have the resources at the Attorney General's disposal in order to prevent future acts of terrorism. Specifically, Judge Silverman and Senator Robb recommended that the Office of Intelligence Policy Review, the counterterrorism section, and the counter-espionage section be amalgamated into under a new Assistant Attorney General for National Security. Currently, these three various components are in three separate organizational boxes. The OIPR with the Deputy Attorney General's Office, the Counter-Espionage section under one separate Deputy Assistant Attorney General under criminal, and the counterterrorism under another Deputy Assistant Attorney General in the aegis of the Terrorism and Violent Crime section. I think each one of these three components are critical to the unifying effort of making sure that lawyers and legal resources are available to guide and assist intelligence agents in the FBI in order to do their job effectively to ensure that all legal authorities are used in order to investigate and prosecute crimes of terrorism, and at the same time ensuring that only those permitted by law are used and in order to investigate and prosecute terrorism. They have both, they will be able to serve both an enabling and a restraining function over counterterrorism and counterintelligence operations that I think currently is missing within the current organizational structure. Much work remains to be done. I think these types of organizational changes are a critical next step in order to effectuate the continuing vision of this committee and of the Congress in passing Section 203, 218, and 905. It does not mean that such organizational changes will ensure success, but they are the next step in the continuing move in order to effectuate culture change, in order to improve the collection of information and intelligence on terrorist activities and activities threatening our national security. Thank you very much.
Thank you very much. Mr. Edgar.
Well, thank you very much, Mr. Chairman and Representative Hastings, members of the committee. It really is a pleasure and an honor to testify before you today on behalf of the ACLU about the important topic of reauthorization of the USA Patriot Act. We stand ready with Mr. Dempsey and a whole host of organizations, both on the conservative side and on the progressive side, to work with you on safeguards to incorporate into the Patriot Act, which I think are really necessary, and many members have said are necessary if we are going to go forward with reauthorizing the Patriot Act. Congress subjected, of course, a number of these provisions to sunset provisions precisely to allow this kind of oversight and second look at the provisions of the Patriot Act. I want to get into a couple specific provisions, but before I do so, I want to address what I think is an overall concern that we all share about the potential shift of the government's surveillance power from a power that is based on open judicial review on the basis of a probable cause of crime standard that supplies notice as a general rule to the target. The notice can be delayed in exceptional circumstances and that sort of thing, to the secret world of the Foreign Intelligence Surveillance Act. It has now been 2 years since the number of orders issued by the Foreign Intelligence Surveillance Court has outstripped the number of electronic surveillance orders in criminal cases based on a probable cause of crime standard that are issued by every other court in the United States, state or federal, combined. The number of orders in 2004 issued by the FISA court was 1,754. Title III, or criminal surveillance orders, were slightly less than that, 1,710. This is the second year running. Previously, for 20 years, the number of orders issued on a probable cause of crime standard had always been larger. One reason this concerns us is because FISA operates in a much greater level of secrecy than Title III and criminal surveillance powers. To illustrate that, I'd like to show everyone this is the public report on FISA powers. I understand this committee receives a lot more information, but we in the public receive only this one page that explains the number of orders that have been applied for and the number of orders received, which is usually the same number. This, on the other hand, is the report on Title III surveillance. It's 250 pages long. It has detailed statistical analysis. It doesn't reveal any sensitive law enforcement information or any information that could lead to the government's not being able to capture criminals, but it does provide us with a great deal of information to understand how the government is using its secret surveillance powers. I'm concerned when the government's powers under surveillance that results in this report outstrip the government's powers in surveillance that results in this much weightier report that results in much more public oversight. I do want to talk about a couple of specific Patriot Act provisions. The first, Section 215, that involves the government's power to obtain private records. Mr. COMEY, I think, was really very candid with this committee the last time he came. One of the things that he mentioned is under questioning from one of the members. He said, well, why would you use this power if you have to go get a judge's approval if you're saying grand jury subpoenas are easier? And Mr. COMEY said, well, we don't always have a criminal hook. I think that is exactly the problem for us on the civil liberties front. When you're talking about the government's power to obtain private personal records where they don't have a criminal hook, in other words, where they're not investigating criminal activity that the records are relevant to, including criminal activity of terrorism, that's going to give us some pause. So the question is really what is going to be the alternative standard that is used that guides the government so that they don't become fishing expeditions into ordinary Americans' private lives? As you suggested, Mr. Chairman, the traditional standard under FISA has been the agent of a foreign power standard. That's exactly what we're trying to preserve, I think, in the proposals for safeguards for this power, as well as some of the other powers that we're talking about. We can talk about the exact degree of connectedness that the records must have to that agent of a foreign power. We've suggested the standard of specific and articulable facts giving reason to believe that they pertain. Mr. COMEY suggested some logical connection between the records and the agent of a foreign power. I'm hoping that with these hearings we can continue to narrow the difference of opinion between the civil liberties community and the government over what connection is needed. What we're concerned about is that, as Mr. COMEY stated, with criminal powers, relevance is self-defining. The question of relevance is whether it's relevant to some criminal activity. With intelligence investigations, we're talking about relevance to an intelligence investigation. And the concern there is that the government is really it just defines, it self-defines that scope of that investigation. If we can figure out a way to confine the scope of the investigation, I think we'd be doing a good job. I do also, so I think with Section 215, we've gotten some agreement on the right to challenge. We agree that there should be a right to challenge. With I'm saying the government and the ACLU, we agree there should be a right to challenge the gag order. We agree that the standard should be tightened up so that it's not simply sought for an investigation, but has some logical connection to an agent of a foreign power. And I'm hoping that if we take our time and do this work right, that we're going to be able to really make that power something that the American people are much more comfortable with. Another point that I think is important that Mr. COMEY made, and that I've heard made by the Inspector General of the Department of Justice as well, is this issue of abuses, and have there been abuses of Patriot Act authorities. I think that there's a couple of things to point out here. First of all, the Inspector General did not report that there have been no reports by anyone of abuses of the Patriot Act. In fact, he reported that one such report, the case of Brandon Mayfield, a Portland, Oregon attorney, is still under investigation by the Department of Justice. The Attorney General testified in front of the Senate that the government did use Section 218 and Section 207 of the Patriot Act in the search of Brandon Mayfield's home. He was suspected of being involved in the Madrid bombing. He was innocent. He was detained for 2 weeks on a material witness warrant and then was let go with an apology from the Department of Justice. I certainly characterize that as an abuse of the Patriot Act, the repeated secret search of Mr. Mayfield's home on the basis of something less than probable cause that he was involved in any criminal activity. Others disagree, but I don't think it's accurate to state that there haven't been any reports. Obviously, there has been that report. I do think that there is a very fair question, which is why aren't there more? And I think the answer to that is that the Patriot Act powers we're talking about operate in secret. That for the vast majority of people, they aren't going to know that their records have been obtained, that their phones have been tapped. Does that mean that there's been abuses? The answer is we don't know. We really don't know the answer to that. If investigations are relying on reports from individuals in the public, as the Inspector General's investigation relies on, then we're just not going to have that information. It took this committee's creation in the late 70s and exhaustive internal investigations to uncover much of what had been going on for decades that led to a lot of the reforms we're talking about. I'd like to briefly address the roving wiretap statute, which I think is something that, again, we should be able to find some agreement about. The government has said that the reason that they believe that the Foreign Intelligence Surveillance Act should have a roving wiretap authority is because criminal investigators currently have that authority for, or had that authority before the Patriot Act for criminal investigations. The real issue, though, is not whether there should be a roving wiretap authority in foreign intelligence investigations, but whether that authority should incorporate sensible privacy safeguards. The two safeguards that we've suggested have come from the identical safeguards that are contained in the criminal law with respect to roving wiretaps. The first one is that a roving wiretap has to name the target, or at least provide an alias or something which can identify who the target is. It's to have a roving wiretap that's essentially a John Doe roving wiretap, where we don't even know who the target is, doesn't provide the kind of specificity that Congress was looking for when they required this identical safeguard for the criminal roving tap. And it seems to me to be a very sensible privacy safeguard. The second safeguard that we have urged is the ascertainment requirement. In common sense language, what that simply says is that when the government gets an order that can jump from phone to phone, an order that resembles at least, or has the potential to resemble, a general warrant of the kind that our founding fathers revolted against the British Crown, that they should at least have to check that the target is using that phone before listening in. That's the same exact safeguard that the Congress put in the criminal roving wiretap statute. So I agree with Mr. Dempsey that intelligence investigations and criminal investigations are not identical, and that we shouldn't necessarily agree that every power has to be identical in intelligence investigations if it's available in a criminal investigation. But I do think that for roving wiretaps and for record search orders, it makes sense for Congress to have at least the same safeguards if they're going to have the same powers as they do for criminal investigations that they have in intelligence investigations. In short, we're not asking that law enforcement tools be taken away. Rather, we're asking that they be made subject to reasonable checks and balances, such as meaningful judicial oversight and appropriate disclosure to the public of the use of those powers. Mr. Comey said that they welcomed oversight, that they welcomed the public asking questions and being informed about the use of their powers. I think that in order to have that public oversight, we need to know something more than just this piece of paper about what's going to become the dominant surveillance law in the United States. Congress could easily adopt most of these reforms by simply adopting the Bipartisan Security and Freedom Insured Act, or SAFE Act, which has been co-sponsored by Congressman Otter, Congresswoman Harman, and a host of other members of Congress on both sides of the aisle. It contains a series of carefully calibrated adjustments that I think would allow Congress to renew the Patriot Act, but give the public some confidence that sensible privacy safeguards have been incorporated so that organizations on the right and left and ordinary citizens know that there's going to be enough judicial and congressional and public oversight of these powers that the likelihood of future abuse under an administration that it does not care so much about civil liberties is greatly minimized. Thank you very much.
Thank the panel very much for your testimony. I just want to make a few comments before I turn it over to Mr. Cunningham for his questioning. You know, it's nice to have a reasoned discussion and debate from the panel on the Patriot Act compared to the rhetoric that has been out there for the last 4 or 5 years about the extremes and all of these types of things. And actually, when we bring experts on the Patriot Act together, we find that there's a lot of common ground and a lot of common recommendations as to the types of changes and the types of reforms that we maybe need to put into it. And that a lot of this is just trying to find the right gradation. It's not talking about sweeping changes. It's kind of like, you know, we got to move it here a little bit there, and thanks for the input on those. That, you know, the committee, we struggle with the question of openness, you know, on just about everything we do, and we try to get we recognize that getting information to the public is very, very important and one of our key responsibilities. And so we do have that discussion on a frequent basis as to what can we make public and what do we need to keep classified. And we take that process and the decisions that we make in that area very, very seriously. So, you know, you've brought up a number of good points, and with that, I will turn it over to Mr. Cunningham for his questioning.
Thank you, Mr. Chairman. You know, I'm just an Irish kid from West Los Angeles, but if Sinn Féin came to the United States and were doing the same things they were doing in Northern Ireland, I would want to use the Patriot Act to go down into suspected areas of both supporters and terrorists and find information out. In San Diego, we had a Jewish temple, a mosque, that were desecrated. I would like to see the Patriot Act expand to where it went into hate crimes. That, to me, that is very dangerous for a citizen's population. If you take a look at where a black church was burned, several of them, or a man dragged behind a truck because of his race. I would like to see that, personally, I would like to see the Patriot Act go in to find out those individuals that perpetrated that. And where Mr. Egan, or
Edgar.
excuse me, Edgar, I'm sorry, said there was no criminal hook. Let me tell you where I disagree with that. And I've already told you the ACLU is not one of my favorite organizations, so you know where my questions are coming from. I'm very straight up. Okay. The Phoenix report, to where they had the individuals that flew into the New York towers were training in Phoenix, Arizona at an airport. They were putting out newspapers, pro-Al-Qaeda, pro-Osama bin Laden, join the jihad, send in money to Al-Qaeda. And yet we couldn't do anything because of the First Amendment. Now, to me, logic says that we ought to be able to go in and take a look at somebody like that that is preaching kill Americans and kill Jews and join jihad. And if you take a look, we had testimony that with our intelligence agencies that there was reasons why they couldn't go in and study those individuals. One was First Amendment. Second was that they were trying to get agents out of Yemen that they were afraid their agents were going to be killed, and they were spread so thin they had to focus on that. But the biggest reason is that if they went in and looked at these groups, they would be sued by the ACLU. This is not Duke Cunningham saying this. This is our own intelligence agencies. And they didn't have the manpower or the money to be tied up in court by the ACLU. Now, to me, this is criminal. And I look at, you say there's no criminal hook. Moussaoui pled guilty. And here's a guy that we suspected of plotting with Al-Qaeda. Padilla, making a dirty bomb. You know, and the cry goes up, well, we're violating these people's rights, when there is a lengthy process that you have to go through to study these individuals. And that's where I'm coming from, and that it just bothers me. And Mr. Edgar, you say the Patriot Act has a chilling effect. You don't believe that any of these individuals are connected to international terrorism?
Well, I think that, you know, if you look at the 9/11 Commission report, the report that this committee and its Senate counterpart did about the Phoenix memo and other things, I just think that it's pretty clear from those reports that the intelligence agencies did have a lot of surveillance powers that weren't effectively used. I think that, for example, if you're talking about a newsletter that says give money to Al-Qaeda, I mean, that is a crime. That was a federal crime before the Patriot Act was passed, and certainly would give the FBI every right to go in and investigate. And any connection with a foreign terrorist group, even without any reasonable indication of crime, allows for infiltration of a group or use of many of these FISA powers. So I just don't think it's accurate to say that before the Patriot Act, the government lacked sufficient power to look at Moussaoui or other individuals that it was looking at.
We've all seen films to where the government abuses civil rights, and we're all appalled. But I think in the case where we deal with terrorism, whether it's Sinn Féin or Al-Qaeda or the KKK, in my opinion, that we ought to be able to go in and to look seriously where we have logical reasons to do so with checks and balances. And I'm not saying the Patriot Act is perfect. It does need to be tweaked in certain areas. But I want to tell you that the ACLU blocks us in so many areas that when you talk about reasonable so that the population can have information, my opinion that the ACLU is unreasonable in this area. And I yield back, Mr.
Mr. Hastings.
Thank you very much, Mr. Chairman. My good friend, Mr. Cunningham, and he is my good friend, expresses his bona fides with reference to the American Civil Liberties Union. Perhaps I should express mine. I'm a former panel member of the ACLU, and until I came to Congress, a paying member of the ACLU. Now, I have some organizations I don't like you do, but ACLU isn't one of them. That said, I think what the chairman said earlier, and that is that a reasoned debate can be had in this very important area as we move toward the renewal or subject the Patriot Act to its renewal or sunset provisions. And it's important that we have that discussion because in many respects, after September 11th, the government was given new powers, and some of those powers, and that's the reason for the sunset provisions, were not subject to standards of checks and balances, and therein lies a part of what I think is a concern for all of us, and that's to make it very clear. Now, the Attorney General has indicated that the Department of Justice would seek technical modifications to Section 215, and two of you have spoken to that particular provision, and these would include allowing a recipient of Section 215 order to consult with an attorney and challenge the order in court. How should it work? Should a 215 recipient be able to consult with his or her own attorney of choosing, or should the attorney have to be approved by the Department of Justice, or should the attorney be required to obtain a security clearance before she's able to gain access to information, or can she effectively represent her client without having access to classified information? And then another one that is really interesting is, should only FISA judges and those designated by the FISA court hear 215 challenges? Or should any federal judge in any federal court hear them? Should the recipient and or the government be able to appeal the decision? And if so, to what court? FISA Court of Appeals or any federal court of appeals? And should a recipient only be able to petition for the narrowing of the search, or should they be able to petition for the quashing of the order? How should Congress, I guess what I'm asking, structure the provision to ensure 215 orders are resolved in a timely manner? Because there is some confusion. Mr. Dempsey.
Congressman, those are important questions, although I want to start out by stressing that the mere fact of judicial challenge, I don't think addresses the questions under 215 fully. The main question under 215 is, what is the standard? The current standard is that the government has claimed that the information sought is relevant to, the statute doesn't actually say relevance, but the administration says that's what it means, that it is relevant to an investigation to protect against terrorism. Now, we have an investigation called Al-Qaeda, or UBL. That investigation is broad. It's going to go on for years. It's been going on for years. We have similar investigations of Hamas and Hezbollah and Islamic Jihad and a host of other organizations, as well as one of Sinn Féin or PIRA. Under 215 as it now exists, all that the government has to do is come in and say, we are investigating terrorism, we want these records, and the statute says that the judge shall issue the order as requested or as modified, period. Now, if Secondly, most of the people who get these orders don't really care. They want immunity, and they get that. They want it over with as quickly as possible. Librarians care, they would probably fight it. A bank, a hospital, an insurance company, a government agency, a merchant, generally speaking, they don't care. If it's secret and their customer never knows, they're just going to give it over, and why pay a lawyer to fight it? So I think the question really is, what is the initial going-in standard to the judge? And I think that's where we're saying, let's make this a real upfront judicial scrutiny. We're not talking probable cause. We're not talking certainty. What we're proposing is some factual basis that links the record sought to some identifiable person who has some connection with terrorism.
Chairman, perhaps we'll come back to it in another round.
All right, thank you. Mr. LaHood.
I wonder if each of you could answer three, well, they're not really three questions, but if each of you could, in the 5 minutes allotted so we don't, go over, tell me, first of all, if you support the reenactment of the Patriot Act, and if you thought it was a good act to begin with. Second of all, if you could tell me what you think the most egregious thing about the Patriot Act is from your point of view. And thirdly, if you were in our position and could make one recommendation for a change in the Patriot Act, what would it be? Start with Seaman and just go down. Thank you.
Thank you. I do support reauthorization of the Patriot Act. I think it was a necessary part of what Professor DINH referred to as the beginning of a culture change. Second, I don't find any provisions of the Patriot Act on their face egregious. I understand that there needs to be an examination of how the provisions are carried out, and that's the role of this committee and others. Third, the change that I would recommend is the one that I discussed in my testimony. It would be a change that would enable the government to use FISA surveillance to get evidence to arrest foreign agents for ordinary crimes, any kind of crime, if the government reasonably considers that to be necessary to prevent an act of international terrorism or one of the other threats.
Congressman, yes, it should be, the powers in it should be reenacted, subject to the kinds of checks and balances I have discussed. My view is fix it, don't nix it. Secondly, in terms of what is the most egregious provision, I guess I would single out Section 215, although that's shared. Also, the same issue arises under 214 and under Section 505. What is the standard for access to these records? And in terms of the change, I think the change would be some meaningful, before-the-fact judicial scrutiny based upon some minimal factual showing, such as I think the FBI, in fact, already prepares internally.
Thank you, Congressman, for that question. I do obviously support its reenactment. I think that the work of Congress in enacting it initially is one that's worthy of praise, working in a deliberate manner in the 6 weeks that it did so, responding to the needs of the country at the time and the continuing need of the country at this time. I do not find any particular provision of the USA Patriot Act to be egregious. I do think there has been an incredible overblowing of rhetoric, creating a climate of fear with the quote-unquote brand of the USA Patriot Act. Some of this results from mere confusion as to what the act does or does not do. Some of it, unfortunately, is, I think, the product of deliberate mischaracterization by certain outside interest groups, which is very, very unfortunate in fanning the flames of confusion. I think that the most egregious product of that confusion is that there has been some genuine fear regarding provisions of the USA Patriot Act, which fears I find to be unfounded, as articulated in my opening statement. However, I think the task of governance is to address fears that are genuine, even if they are unfounded. So in that sense, in addition to endorsing Mr. Seaman's recommended change, I do think that some crossing the T's and dotting the I's may be in order along the lines that the Attorney General has suggested in order to assure the American public that Congress did not intend and the government does not interpret provisions of the USA Patriot Act to do what the outside interest groups have confusingly mischaracterized these provisions to do. For example, with respect to Section 216, I think the provision requires, and the law requires, particularity and specificity in the articulation of a subject of a surveillance order. Otherwise, it would be in violation of not only the Fourth Amendment, but a whole host of other constitutional provision. But do not mistake specificity with identity. You can have an alias. The alias will be John Doe. You know exactly who that person is. You just simply do not know what he calls himself. For example, if somebody's meeting with a spy and having conversations relating to their activities, you would not necessarily know the person who is talking with this spy. I think that is the specificity and the evidence that is necessary in order to sustain a 216 order, but at the same time, do not require the specific identity that would unnecessarily circumvent a legitimate investigation. Likewise, with respect to Section 215, I think the ability of a recipient to consult a lawyer is there is implicit in Section 215 in the provision that allows the recipient to consult with persons necessary to comply with the order. And a lawyer certainly would be a person necessary to comply with the order. I think the ability for judicial review is implicit in normal, ordinary criminal and civil procedure in the sense that you can go to any court in order to challenge any governmental action. And when a court gets such a challenge, it would look at the underlying authorization of governmental action here, the authorization of a FISA order or the 215 order by the FISA court, and whether or not the court hears the action in the first instance or refers it back to the court of issuance, that is the FISA court, is a matter of discretion in the ordinary criminal and civil procedure practice. But all of these things, even though implicit, should be made explicit so that we take care of those genuine, if unfounded, fears. Thank you very much.
Well, thank you very much. I would, I guess, endorse to some degree Mr. Dempsey's statements. I believe we should either fix the Patriot Acts or nix it, and I hope we don't have to do the second. I hope that it'll be possible to incorporate safeguards and checks and balances rather than allowing those provisions to expire, and I think it's possible to do that. I do think that some of the suggestions for expanding the Patriot Act have been ill-considered. Certainly, using FISA surveillance for the sole purpose of trying to find evidence of ordinary crimes that a person may be involved in is clearly a violation of the Fourth Amendment. It's the reason that one of the most conservative courts in the entire country, the FISA Surveillance Court of Review, appointed by Chief Justice Rehnquist, rejected that argument. I think that if Congress were to adopt the amendment suggested here, it would go a long way towards rendering the FISA statute unconstitutional. I believe that they have already nicked away at some of those important safeguards that uphold the constitutional basis for FISA, and that would possibly strain it to the breaking point. I also believe that in order to have a meaningful right to challenge a Section 215 order, you need to be able to consult with your attorney, not just in order to be able to comply with the order, but in order to be able to challenge it, and that your right to challenge has to be meaningful. It can't be based on an obscure procedure. You know, the FISA court is not an ordinary criminal procedural process like a grand jury procedure that people are going to be familiar with. And so I think there's a right way and a wrong way to put in an explicit right to challenge a Section 215 order. And if we put in a right to challenge, for example, that's limited to the FISA court, that greatly restricts the type of attorneys that can appear before that court, we may have on paper a right to challenge, but that's not going to be meaningful for a large number of people. So I hope that we would have a right to consult an attorney, not just to comply with the order, but also to challenge it where it's appropriate, and that they would be able to do so in a way that's going to be realistic for most small businesses in this country, most individuals in this country that certainly have never heard of the FISA court and wouldn't know the first thing about how to file an order there. I think that those kind of sensible safeguards, and you ask me what the most egregious thing in the Patriot Act is, rather than naming a specific section, I would say that it's the problem that exists in a number of the sections of meaningful judicial oversight and excessive secrecy. And I think you can solve that problem by creating more meaningful judicial oversight and by limiting secrecy so that, where it's necessary, where, we're talking about sources and methods and things that this committee cares a great deal about protecting, we preserve that. But where we do allow a greater ability, both for people who are challenging orders or for the public, to see just general information that will be helpful in understanding how the government's powers are working in practice.
Mr. Ruppersberger.
Well, this has been a very good discussion, and the Patriot Act was new, but we needed to give the tools to law enforcement to react what happened. And we're in a new situation as it relates to terrorism. Now, one of the issues that I feel is very important when you start a new law and we're moving through the process is the issue of sunset. And it seems to me there's, from what I've heard from some testimony, I think it was from the Attorney General's office, there's a concern about sunset. I think sunset, until we know where we are as we relate to rights, might be a very good thing, because what it does, we go forward with the Patriot Act, but then in 2 years, if we sunset it, Congress has the ability to oversee any abuses that might be there. I remember looking back in my file, and that I think there's been one actual complaint with respect to the Patriot Act. Now, I wonder first who is making, when those complaints are being made, and there were over 1,000 complaints, who is adjudicating whether or not those complaints are legitimate. So I'd like you to address, I guess starting with you, Mr. Dempsey, and then the panel, the issue of sunset, and then secondly, the issue of complaints, and then if we have a chance, I'd like to get to the roving wiretap.
Congressman, in 2001, I was skeptical about the sunsets. But it turns out, in retrospect, that they were a brilliant idea. They have worked. They have worked in the sense that the committee is holding this kind of a hearing. It's forced the committee to come back and reconsider. Secondly, it has forced the administration to be more forthcoming in information. You fight sometimes for the information you get. More information has come forward. Third, I think the sunsets have been very important because they have said to the government, be careful. The FBI wrote a memo to its field on the national security letter provision, Section 505 and 358 of the Patriot Act. And they said that national security letters are powerful investigative tools. Even the FBI admits that this is a powerful tool. They said they must be used judiciously. The USA Patriot Act, this is quoting from the FBI's own internal memo, the USA Patriot Act greatly broadened the FBI's authority to gather information. However, the provisions of the Act are subject to a sunset provision that calls for their expiration in 4 years. In deciding whether or not to reauthorize the broadened authority, this is the FBI, Congress certainly will examine the manner in which the FBI exercised it. So because of the sunsets, the FBI was careful. Now, if we remove the sunsets, what are we going to put in place that forces that care and that caution? An alternative, as I think you're suggesting, is to continue the sunsetting process, put another 4 years, come back again, look at them again. But how do we somehow put this kind of caution on the use of what even the FBI admits are powerful tools?
Okay, does anyone disagree with Mr. Dempsey said that has a concern with the sunset? Yes,
I do have some not specific concerns, because I generally agree that sunsets are a good tool for oversight. But you should not need sunsets in order to do oversight. I think this committee and Congress abdicates its constitutional responsibility to oversee the administration and the executive branch if it has to put constraints on itself in order to do oversight. I think that is an active part of your constitutional duty.
Let me say this to you on that issue, though. This is a new law, and we know we need to give our, especially FBI, the tools to deal with terrorism. But why in the beginning stages, when we're trying to go through this process and we're trying to seek the balance, why I mean, we're new at this, and the sunset holds accountability and gives the Congress the oversight that it does need.
At the end of
Because
the
remember,
day,
there are a lot of people that are very fearful out there. A lot of Muslim Americans, as an example, who are very concerned, and they're Americans also. But we also need to do our job to protect our country too. So I'm really.
I completely agree with you, Congressman, that the oversight process is utterly critical, and it has worked in the last 4 years. At the end of the day, during the process, if you recall, in 2001, we did not oppose the sunset on a different theory, that there would be no abuse of these powers because the checks are in there, both in terms of administrative and legal constraints. My one reservation with respect to sunsets in general and sunset in this particular instance is the need for transformative cultural and organizational change, especially with respect to provisions like 203, 218, and 905, which only authorizes but does not mandate the organizational changes. I think that putting in a marker in place gives bureaucratic tension opportunity to flower into passive-aggressive activities that will thwart the transformative cultural change that is necessary in order to effectively
You say
protect against terrorism.
cultural change comes with experience too. My time is up. I say.
Mr. McHugh, thank you for showing restraint today.
Thank you, Mr. Chairman. I apologize to all, particularly our witnesses, for walking in late. I was detained in other matters, but those portions of the discussion I've heard are very interesting, very helpful, and I appreciate the spectrum of opinion that we have here. I don't really have any break ground questions, but I have been reviewing the testimony, and I guess it is there that I just want to ask a couple of questions for clarification, so I make sure I'm understanding what you intended us to understand. Mr. Edgar, when I came in, you were discussing in general terms at that moment your concerns about abuse of the Patriot Act. The one example I heard you cite was that of Brandon Mayfield, and I think most folks would agree it wasn't our shining hour with respect to FBI investigations, and in fact, I think Attorney General COMEY, in fact, had stated as such in an open hearing we had a previous week. You said you felt that demonstrated an abuse of the powers under the Patriot Act.
Well, yes, Congressman, because the problem there, as the Attorney General acknowledged, they used Section 218 and Section 207, changes to the FISA statute, to make it possible to have a secret search of Mr. Mayfield's home, and they did so on the basis of less than criminal probable cause. Now, we couldn't go back in time and know whether the same thing could have happened or would have happened if there were a criminal warrant that were used, a normal criminal warrant, rather than a FISA warrant. But certainly, my firm belief is that if the Justice Department had to meet the standard of criminal probable cause, it would have at least been much more likely that they would have caught some of those mistakes on a much earlier basis. Now, the answer is, what are we going to do about it? I mean, we've heard testimony.
May I ask a clarification
Yeah,
question first, because it's my understanding, and I may be wrong, and the reason I wanted to get your perspective, that the troublesome things you cite were in large measure predicated upon a misidentification of a fingerprint, and it kind of cascaded from there. If that sequence is incorrect, that's what I'm trying to find out.
No, I think that sequence is correct. What I'm suggesting is that if the evidence is shaky, if the fingerprint identification is wrong or other evidence is shaky, that if the government has to meet criminal probable cause standards, it's going to be more likely to catch that before issuing the secret search warrant. Now, I do think that there is a good question about what do we do about that, because a lot of people believe the significant purpose test is really important and don't want to throw it out. So I think there are some good answers to that. For example, we know that these kinds of FISA powers are going to be used much more with respect to cases that involve criminal prosecutions now as a result of the Patriot Act. And so one suggestion has been that we should give those people who are facing FISA surveillance in court against them greater access to the information that underlies the FISA application. They would be given, under the Classified Information Procedures Act, more access to the affidavit and other information that was shown to the FISA court in a summary form that would be unclassified. The idea, I think, here is to give essentially more oversight to the use of this information in criminal cases and still preserve something like the significant purpose test. So there's, I think, an example where, you know, you have something that did lead to an abuse, but the answer may not be to throw out the power. It may be to try to fix the power in some way that gives us greater oversight.
I think that's just, that is, I'd have to disagree. I think that analysis could equally say that it was an abuse of driving license power because the FBI drove to in order to execute the search warrant. The underlying mistake here was the misidentification of the fingerprint, and a whole lot of things happened after that misidentification. It doesn't mean that the USA Patriot Act was abused any more so than driver license authority was abused.
Well, I mean, I do think...
Could I just,
Go
for
ahead,
1 second?
Mr. Dempsey.
I'm not sure that I would call the Mayfield case an abuse of the Patriot Act per se, but it does open an interesting window on intelligence investigations and how quickly they can get out of control. And what was unique about that case is I think that the Spaniards were saying, and ultimately started saying publicly, you have the wrong guy, you made a mistake. And that, if it hadn't been for that, and of the role of the Spaniards, I'm not sure that the mistakes there would ever have come to light. And with the secrecy, et cetera, and also what's disturbing in that case is I think it's hard to deny that the fact that Mayfield was a Muslim that's pretty clearly seems to have influenced the thinking of the FBI in that case, which also shows you how intelligence investigations do slip over into that area. I'm not saying that that's itself bad. We clearly have a ideologically motivated terrorism that we face, but it shows why there's this need for extra caution and these extra checks and balances.
Thank you. My time has expired, Mr. Chairman. Thank you. Thank you, gentlemen.
Thank you, Mr. Chairman, and I want to commend the committee chairman for once again holding a public hearing. Certainly the Patriot Act was born, practically moments after our country was attacked, and not having public hearings, understandably at that time, I think really led to the very, very bad rap that the Act has in the mind of the American people. And I think for many, that reputation is not going to be able to be rehabilitated. But having said that, I think that these hearings are very important, and I think that they're enlightening to all of us, and I thank the witnesses that are here today. I was just reading in the committee binder here, and it's just at the very end, an article that was written in the National Journal, and I thought that it was, many parts of it are interesting, but I want to place into the record a part of it. It said, he says, this is Stuart Taylor Jr., consider what the ACLU says when it is seeking to be taken seriously by people who know something about the issues. Quote, most of the voluminous Patriot Act is actually unobjectable from a civil liberties point of view, and the law makes important changes that give law enforcement agents the tools they need to protect against terrorist attacks. That's right, that was the ACLU talking in an April 5th press release. So I think that, the thinking of what I refer to of the American people and the bad rap really creeps into the hearings that we have as well. People really think of one another and where they come from in very small, tidy boxes, and I think that that is not healthy. So I appreciate all the comments that have been made here. I want to I also want to make another observation, and it's what it was the comments that I made and the questions that I asked in the first public hearing on this of the former Assistant AG, Mr. COMEY, and that is that I think the abuses of the administration are really attributed to, so many of them are attributed to the Patriot Act. And that is another layer of discontent and suspicion and anger and the volatility that is out there related to the subject that we're here to discuss. And that relates to deportations, people being held without charge, the abuses that have happened during detention, and the whole issue of torture and moving people around to other countries so that torture can actually take place. Now, we don't ever want to think of our country doing things like this, but these things have happened. And so we're dealing with many, many layers of things. But what I want to do is try to peel back some of those layers and try to move on with some of the enlightenment. Number one, I think that this committee should report out as part of its recommendations that sunsets actually are kept in place. I agree that it is the responsibility of this committee in terms of oversight and investigation. But when you have oversight and investigation relative to intelligence matters, then the ownership is spread to at least 400 other members of the House. And I think that that is something that's very, very important. And it gives the American people a sense that we are all going to be vigilant on this, that we're open to continuing to take a look at this, and not that it just remains within the reins and the realm of the House Intelligence Committee and the Senate Intelligence Committee. So I think that that's very important. A specific question on to the panel on the lone wolf provision. It's only been law for a short period of time, for a few months, not long enough for Congress and the DOJ and the administration and the American public to have time to fully assess its impact on civil liberties. I want you to just tell me as briefly as you can, what are your thoughts about the new authority? Should we be concerned that it's overreaching? And if so, what changes would you suggest? So we can start.
Yeah, Congressman, I think
start to my right.
thank you very much. I mean, I think we're concerned about the general erosion of what has been the constitutional basis of FISA, which is, you know, in the court decision, United States District Court versus United States, called the Keith case, really the Supreme Court laid the groundwork for intelligence surveillance on the basis of surveilling people, wiretapping people who were acting for foreign governments or international groups like terrorist organizations, and we created a whole separate, more secret regime, not based on criminal probable cause, for that specific group of investigations. Lone wolf is the first kind of crack in that regime that allows the government to use that regime for someone who isn't even suspected of acting on behalf of any foreign power at all. And that same decision, again, by one of the most conservative courts in the country, really relied on that to uphold the constitutionality of FISA. So I'm concerned that if those cracks are made wider, that either we will shift virtually, even more of our surveillance into that secret world, that should be under Title III, criminal probable cause, or that the whole thing will come crashing down. I think that would be very bad for national security.
I wholeheartedly endorse and support the lone wolf provision, otherwise known as the Zacharias-Moussaoui provision, because the origination of the provision is very simple. FISA requires a link of an agent of foreign power to have links to a terrorist organization as a foreign power. In early stages of the investigation—
But Mr. DINH, if I just might interrupt, but we now know that this provision would not have helped the FBI out in August of 2001 when the FBI was attempting to gather more information on Moussaoui. So I think that needs to be set down as well.
I think there is a continuing debate, if you will, as to what would have happened in the game of counterfactual history for all with relation to Zacharias Moussaoui, with relation to all of 9/11 altogether.
It certainly is not as definitive as you just stated, though.
No, it is not as definitive. I will stipulate to that, even though we're not in a court of law. But I do think that the logic behind it is very, very straightforward. A lone terrorist, whether or not acting in concert with a known terrorist organization, poses as grave a danger on the security and safety of the American people as a terrorist working in concert with an established terrorist organization. I applaud Senator Schumer for pushing this issue after the USA Patriot Act, and when his staff brought it to our attention, we instantly recognized that we missed an opportunity in the USA Patriot Act to fix the problem as it then existed and continues to exist.
I think that the lone wolf provision probably needs more time for examination. It was synced up with the Patriot sunsets, but really we don't fully know what has happened with it. And I urge this committee, by the way, to look closely at some of those FISA applications, the U.S. person ones as well as these lone wolf ones, and really see what's going on in those cases. I think there is a broader question here about what is the underlying rationale for FISA in the first place. And Mr. SEAMON has raised a proposal, which is the first time I've heard it discussed in public. It's been floating around, but I've testified at 5 Patriot Act hearings in the past month now. And this is the first time I've heard this supported or proposed, which would truly break down this distinction between, we have foreign threats over here, we have organized groups, etc., and then we have the tremendous powers of the criminal law, but where we're investigating crimes. And as I said in my opening statement, FISA investigations are not limited to investigating crimes. They're not limited to investigating illegal activity. But once we start using those FISA cases for the sole purpose of collecting criminal evidence, and see, I think the mistake in the Moussaoui case, there were a number, but the big mistake was not going the criminal route. They probably could have gotten a criminal order. They probably also could have gotten a FISA order, because the FBI was misreading the statute, as people have since found. They probably could have gotten a criminal order and probably should have. And now that the wall is down, and by the way, not a single witness has complained today about the taking down of the wall. Professor DINH has focused on sections 203, 218, 905. Nobody has complained about bringing down the wall and sharing the law enforcement information with intelligence and vice versa. That wall got totally perverted. It wasn't serving any good purpose. So you can go the criminal route against the solo, the lone wolf, and that should be the approach.
I think that Mr. Dempsey illustrates the need, the reason that we needed to bring down the wall. There is not the sharp distinction between criminal law enforcement and countering foreign threats that his remarks suggest. The reality is that prosecution and arrest are tools of countering terrorism and other foreign threats. They're not always the appropriate tool, but sometimes they are the best tool.
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Well, I'm not quite sure where to begin, whether to proceed on that. You know, we would all benefit, I think, from a better knowledge of history, but I think there certainly were periods in decades past when non-citizen foreign labor agitators were considered criminals, but worse than criminals, or where people saw Bolsheviks behind every bit of unrest in the United States. So I worry about both the wall and the lone wolf provision. Let me, recognizing that suspects are always suspect, I think we've got to pay some attention not just to whether the Patriot Act, let's say Section 215, for example, is, provides acquisition of records that it's too easy and too broad and don't require articulable facts, and turn to what I think we've got to make absolutely sure that we do, and that is protect the rights of defendants. I mean, we want to do what we can to make sure that they don't get swept up unfairly, and we want to make sure that ordinary Americans don't live in constant fear that their medical records will be swept up in an overly broad search. But if somebody ends up in court, we want to make very sure that the defendant's rights are protected. And so, I wonder, you've addressed this a little bit, but I wonder whether we should make sure that that they have access to the information that they need to defend themselves. I mean, how would we write legislation? What would the language say, for example, that would allow them to have? Mr. Edgar, you began to address that earlier.
Sure. I think the question here is that when FISA was first written, and we did have something of a wall, there was a sort of a feeling that maybe if our intelligence wiretaps uncovered some criminal evidence, at some point they'd have to throw it over the wall, but that this would not be a very common occurrence. And I think that because of Section 218 and other provisions of the Patriot Act, that assumption has to be rethought, particularly if we start adopting ideas like we've heard today of using this FISA surveillance to gather evidence of crime. And the real problem here is that when you deal with Title III surveillance, that is, wiretaps that are based on probable cause of crime under the federal criminal wiretap statute, the amount of information that a defense attorney obtains is fairly significant. I mean, we're talking about the wiretap application, the affidavits that support the wiretap application. That all becomes part of the record of the court case, and there can be litigation about whether the wiretap was lawful, and lots of other issues that come up in court. FISA, as you know, is classified information. The government has taken the position that everything but this sheet of paper is properly classified when you're talking about FISA. And so the information that's disclosed to the defense, where the wiretap is a FISA wiretap, is far less, basically limited to the information that the government is planning to use against the defendant, and there is a constitutional right under Brady to direct, exculpatory evidence. We're suggesting that you can use already in the law, there's a law called the Classified Information Procedures Act, which is generally supposed to deal with the issue of classified information in criminal courts.
And doesn't require a FISA judge. I mean,
that's right.
Other judges could use it.
Any district court can use that to oversee the creation of an unclassified summary of all of this information that you would normally get if it was a criminal wiretap. And I think that strikes a much better balance in a world now post-Patriot Act where FISA surveillance is going to be used far more often in criminal cases, where it's not just an exception that happens every now and then, but is something that is going to be much more the norm.
I think this is
we're out of time. Let me, well, I guess we're totally out of time. So, okay. I'd like to pursue that with all of you, but there isn't time. Let me just get to a single question. Do you think that can be answered, I think, briefly? Is the Patriot Act emergency legislation, or, maybe this is a loaded question, should we have passed this many decades ago when we feared, I don't know, Bolsheviks in our, were spreading dissension in our country?
Well, I think certainly that by creating a sunset for some of the provisions, Congress recognized that it was acting without all of the due deliberative process that it would if we were making sort of permanent changes to the law, that it was acting as a result of the 9/11 emergency. And I hope that in this process of re-looking at the Act and seeing if there are additional safeguards, that we understand that when we reenact the Patriot Act, whatever it was to begin with, whether it was emergency law or whether it was permanent changes, it's going to become something like permanent changes. Even if we do put in another sunset, which I favor, I think it's going to become more permanent as we reauthorize it. And so we should think about that. We should think about what should our laws be, not just in an emergency, but really pretty much from now on. For the fight against terrorism is not going to be coming to an end very soon, and so we're going to be talking about, I think, what are going to be permanent changes, even if we do have sunsets that allow us to look back at them time and time again.
Okay, I wish we had more time. Thank you.
Is that all the gentleman has? Okay. The chair's intent, we have Mr. Tierney will go next, but Mr. Boswell is in the batting box, and we have Ms. Wilson unless someone comes out. We have till 11 o'clock, and I haven't limited anybody's time because I think it's everybody's, you see, we're as anxious for information as anybody else and what your views are. And I'll try and divide the time evenly, but I'm not going to limit to, to 5 minutes because I think the discussion is good. I just want to give everybody an opportunity, and with that, Mr. Tierney.
Thank you. When we had the first panel last week, Mr. COMEY and I had a discussion about the John Doe roving wiretaps. And during that discussion, he indicated to me that the administration didn't read those provisions of the law to be as broad as some people do. I mean, I know there's a lot of talk about people thinking that it allows the FBI to tap any phone used by an basically unidentified person. Would each of you agree that we ought to require some particularization of a description before we allow a tap on a roving phone? And if not, why not? What would you do? Starting maybe left to right, if we could.
I understood the Justice Department's position to be that the existing law requires a description of the person who is the subject of the target of the tap, and to the extent that that's not made clear in the existing law, I think it should be amended to clarify, recognizing that in certain situations the government may not at the beginning of the process even be able to supply as much as an alias, but only a physical description.
Thank you.
My answer to your question is yes.
Thank you.
I think Section 216 does and should require particularity and specificity of the target, if not necessarily the identity or the known identity of the target. Yes.
I just say that I think that the criminal statute requires identity. I see no reason why that shouldn't be required for FISA. And to tell you the truth, when I first came across this anomaly that basically you could have an unknown roving wiretap, I honestly thought it was a mistake. And I was very surprised that the Justice Department opposed our change. And that was one of the things that gave me some concern, is that I felt that this was a drafting error, and I didn't see why there would be any resistance to changing the law to specify exactly the same thing that roving wiretaps say in criminal law, which is that you need the identity. Not necessarily the name, but you need the identity. And if you don't have the identity, you can get a wiretap of a specific phone where you don't know who the target is.
Well, I think we're getting in that direction. Mr. Comey indicates that he believes that they have a human being that they describe with sufficient particularity that the FISA court can conclude that the person is an agent of a foreign power. So if we maybe define the language so that everybody's happy, it seems that at least people are thinking in that same direction, whatever, I think would be helpful to make it certain. Let me ask you about information sharing, as we were talking about a minute ago. Are we favoring quantity rather over quality? Should we narrow the universe of data that is shared? For instance, shouldn't the focus on the information shared be that it's closely related to suspected terrorism before it gets shared? Rather than indiscriminately put all of the information that's received into some general database, should we rather narrow it down to giving it or sharing with just those officials that are engaged in investigating terrorism? And when we have data that's collected subject to a special power of the court, whether it's wiretaps or secret grand jury material, should we have the judge approve before that data gets simply dumped into some general database?
Maybe we should go left to right this time. I mean, I think those are good ideas, good suggestions. We've proposed something a little bit less restrictive after the fact notice for information that's acquired through criminal powers. I do think quality over quantity is a serious problem. As I understand it from a number of people that have looked at T-Tech and some of these other areas, there is possibly a swing to the pendulum in the other direction. And I don't think that simply dumping huge quantities of information into a database is necessarily going to be the most effective thing. If we can limit the information more closely to terrorism and more closely to the people who need it, I think that would probably be a good thing. But I mean, there's no question that information sharing is important, but it has to be good quality information.
I don't think neither quality nor quantity of information is as important as what you actually do with that information. And the TTIC example is illustrative of the need for what I call the transformative organizational changes along the lines of what Senator Robb and Judge Silverman have recommended in terms of reorganizing the FBI and the Department of Justice to make sure that you have the ability to collect, follow up, and analyze and put to good use information. Something, I guess, along the lines of integration of information and action rather than simply sharing of information across artificial organizational boxes.
Well, if I follow up on you, are you saying that you think it ought to be narrowed down as to whom it's shared with rather than just dumped in a general database, that you're using specific people for specific investigations into terrorism and restricting it to them?
It depends on what the use is. I think there is a very, very significant need for strategic intelligence analysis, which is currently not being served, at least with respect to domestic threats. The CIA does a great job in terms of strategic analysis of threats. I think the FBI has a long way in order to get there. In that kind of strategic analysis, you need a lot of information and the brain power in order to pull it together. That's different from a particularized investigation in which more specific, better information would be necessary, and better in terms of not only the specificity but also reliability that comes with asset validation. That is ascertaining the credibility of the source of that information.
Thank you.
Congressman, this is a hugely important issue, obviously, and I think your instinct is correct that there is a certain quantity over quality phenomenon now. In these issues, we are straying outside of the four corners of the Patriot Act and into the realm of the intelligence reform legislation and the role of the DNI. These are critical questions. I would note that in the Patriot Act, the definition of foreign intelligence is extremely broad. The sharing of information not only includes information concerning the national defense and responses to terrorism, but any information, whether or not concerning a U.S. person, so including U.S. person data, with respect to a foreign power or foreign territory that relates to the conduct of foreign affairs of the United States. And then that information can go to anybody in law enforcement, protective, immigration, defense, national security, et cetera. And I think it's very hard to legislate these things. It's very hard to force people to change culture. To some extent, the pendulum swung a little bit too far, and there's still a debate, I think, ongoing in the administration. What does information sharing mean? Does it mean you throw it all over the wall and let the other guy worry about it? Or do you have a more particularized, more need-based, and I don't want to get to need to know, I'm not talking about that, but we need to have, I think, a better definition of roles and responsibilities, and so that people can get and use the information within the context of their roles and responsibilities, find it, get what they are going to work with, but not this sort of dump it into a big database. And that issue, I think, it remains in the balance and is being clearly, there's an effort to try to work it out in the administration. This committee has a huge role in that as well.
I have nothing to add.
Thank you. Thank you very much. I yield back.
Mr. Boswell.
Thank you, Mr. Chairman. I appreciate the response and the tone from the panel. I appreciate it, Mr. Chairman. I think we're having a good session. I got here, I apologize for being late, but Mr. Hastings was on a subject matter and would like for some of the rest to respond as well as Mr. Dempsey, but particularly give some focus on should an attorney be required to obtain a security clearance before he or she is able to gain access? Or do you think they can effectively represent their client without having access to classified information? And the other, should a recipient only be able to petition for the narrowing of the search, or should they be able to petition for quashing or elimination of the order?
Congressman? It's great you asked that question, because I just came from a meeting a couple of days ago with the counterterrorism section. Mr. Sabin invited me to talk with their attorneys, which was really a very productive brown bag lunch we had, and we discussed this exact issue. I think that their perspective was that they wanted to have the Foreign Intelligence Surveillance Court be the court that heard the motion to quash. We were concerned that that might make it less meaningful for lots of people who are small businesses or others around the country wouldn't know how to do that. But they did seem open to the idea that at least in many circumstances, if a Section 215 order was being challenged, that there wouldn't necessarily need to be a security clearance. It depends really on the grounds for the challenge. If the grounds for the challenge is that this order is overbroad or unduly burdensome or oppressive or seeks privileged information, it may not really matter that much what the order is based on. The effect on the person who's receiving the order is really what the court is considering. On the other hand, if we had a standard, which I think is very important, and if that became relevant to the motion to quash, there might be classified information that was involved. The other thing is that the attorneys there, I think, were comfortable with the idea that you would have a broad motion to quash available. I think they felt confident that they would win most of these motions, but that it would allow narrowing or quashing altogether of the motion to quash.
I think I will let the Department of Justice speak for itself, but I would point out as to where they think the proper line is. I would point out that even in proceedings in the FISA court need not be classified if it does not involve classified information. And so the fact of confidentiality of a 215 order doesn't mean that the order itself is classified. So I think that depending on the basis for the challenge, you don't need access to classified information in order to make that challenge, and only where it's necessary would you need to have a security clearance.
Anybody else with an opinion? Anybody else?
I'd spoken to this before, Congressman, but I just think that the complexity of these questions suggests to me that we need to put our emphasis not on how you structure the challenge, but on what the judge asks for in the first place.
Well, thank you, Mr. Chairman. Anybody else on the panel up here on this end want to participate? You're invited.
Yeah, Ms. Wilson is on the telephone. I got just one question. Maybe Mr. Tierney could answer it as good as for me, and then I'll go back to Mr. Tierney if he wants. But in the issue, if a charge is brought against somebody and it's very classified information, it interested me, Mr. Boswell's question. And I tried to read the Patriot Act, the actual act, and that's where I think Mr. Tierney and some of the guys have been lawyers who are the party of the first part in this. It's hard to read and to get into it. I had to sit down with some of our guys that were lawyers and explain what the party of the first part meant. But when you have someone that's charged and it may be classified, even the judge, as far as bringing forward the information, what do you have to do, or what would you recommend doing, and or the lawyer that's either representing or the lawyer that is basically challenging the individual? How do we get around that unless we have, and I'll go.
Congressman, that's been largely addressed in a statute that Congress adopted in 1980, the Classified Information Procedures Act, which sets up a procedure in advance of the trial for considering what will be introduced and making sure that the defendant, for example, does not commit gray mail, basically threatening the government with exposure of sensitive but irrelevant information in the course of the trial. And you resolve those issues in the judge's chambers with just the judge, the prosecutor, and the defense lawyer. Defense lawyers do get clearances. They are bound and have lived by that obligation.
What level of, is he cleared for secret, for top secret, the judge?
By and large, by the time you get to trial, the government has made the decision that they are going to declassify certain information. When they
But
look,
what if they have to interject classified information that they know that this individual would be harmful to the United States? And
then at that point they are,
Mr. Edgar said that there ought to be a way to, offer to squash, I guess was the term you used.
when push
I don't
comes
know
to
how
shove.
that would work.
No, at the very end, you negotiate that back and forth, and the judge is in the middle working that out. If at the end of the day, the judge concludes that there is some piece of information that is relevant to the defense that the government refuses to declassify, then the government has to withdraw the charge.
If I may.
And that has happened, though, only in the Iran-Contra case, where the issue was over something that I think could easily have been declassified, but that got political,
I want to give
clearly.
Mr. Tierney time, but if you could answer succinctly, and I'd like to
Yeah,
see.
I think that, actually, can I just go for 1 second? Because there may be the danger of very severe misunderstanding here, as in context with respect to Mr. Holt's question also. That is an accurate, perfectly correct answer. It is not necessarily a complete answer in the context that we're talking about. When a court faces in criminal proceedings FISA-derived evidence, as the Middle District of Florida is currently facing in the prosecution of Samuel Arian, and the defense seeks to suppress that evidence as being collected in excess of statutory or constitutional authority, three possible regime may apply. The standard Fourth Amendment suppression regime, the Classified Information Procedure Act process that Mr. Dempsey just identified, or the suppression process that is identified and codified in the Foreign Intelligence Surveillance Act itself. I think it is a little bit premature right now, given that these issues are being litigated in many circumstances in the first instance by the Middle District of Florida, for us to venture as to how we should, how you should treat it legislatively. I think the process that the Middle District of Florida is going through will help answer a lot of these questions, and especially after review by the 11th Circuit.
Mr. Edgar,
Yeah,
and then I'll go to Mr. Tierney.
Thank you very much, Mr. Chairman. I mean, I think that the Classified Information Procedures Act is just a classic example of an excellent statute that was written in order to balance very difficult interests. We're talking really about secret evidence. I mean, before that act passed, the government was faced with a very stark choice. They had to make the evidence public, or they had to drop the case. And so this gave them the tools that they needed to go to a judge and yet still satisfy the Constitution's standards. And I think what we're talking about here with its application to FISA is really a loose end that was left untied, probably because it was such a rare event. And Mr. Chairman, I just wanted to call your attention also that our executive director Anthony Romero has come into the room, and I'm sure would love to talk with you about your concerns about our organization, and to say that I understand that we provoke a lot of strong feelings. One thing we've tried to do in the Patriot Act is to work with organizations that I personally might have real strong feelings about, the American Conservative Union, the Gun Owners of America, and other groups, because we do agree, although we disagree on a whole lot, we do agree on certain aspects of protecting personal privacy, and I think it's an example of the old adage that in Washington you have to put together coalitions where you're uncomfortable with the other people.
I'll agree there are good people and bad organizations.
Well, thank you very much, Mr. Chairman.
Thank you. And I promised Mr. Tierney I'd come back to him.
That's right. I think we move on. I just want to say that this act, of all acts that I've ever seen, has certainly put some strange bedfellows together on that. I'd like to defer to Ms. Wilson, would ask just one question, and that is very briefly, what information or what feedback do you have on the authority for nationwide execution of search warrants? I'm thinking in terms of large data storage facilities, communication facilities. Have you heard any feedback on that? Originally, people thought that would be incredibly burdensome and difficult for some to comply with, as opposed to being able to have it done in their own district where they might have their business. Anybody? Nothing?
Well, I just say this is an area where I think the conservative organizations in our coalition have been, if anything, more concerned than we have because of the federalism issues. And what we're most concerned about is judge shopping, the idea that the government might use this to get a favorable judge where they didn't get one in another district. I think we don't really have a lot of information about how this is being used. So we've urged that there be some reporting and other requirements, that the Congress be able to maybe re-sunset this and take a look at it after we have more information about how it's been used.
As a self-described conservative and card-carrying member of the Federalism Police, I don't think there is any federalism concerns with a nationwide search warrant because it's a question of venue rather than federal-state relations. I think that the problem with single district subpoena is basically a shoe leather cost that really doesn't add any civil libertarian protection, because we've never encountered any federal judge not relying upon the approval of the initial judge. And so basically you have a lot of agents, a lot of lawyers running to courthouses all around the country, wasting a lot of shoe leather and, more importantly, critical investigative time without any significant or even identifiable substantive civil libertarian protection I can see.
Thank you. I yield back. Thank you.
Thank you, Mr. Chairman. I'd be happy to yield my time to any of my colleagues who have additional questions. I really appreciate the written information, which I find to be extremely helpful in dealing with this issue, and I really appreciate the thoughtfulness and time that you all put into that. I appreciate it, and be happy if Mr. Tierney or Mr. Boswell or even you, Mr. Chairman.
No, I'd just like to say that I think this is one of the better hearings we had, because I think you'll see that members up here are as interested in what the right thing is. I mean, some of us have our own opinions, but sometimes those opinions, you know, we state our opinion as fact and we're factually challenged. So I think it's always good to get different hearings and yes, from the ACLU, to get to some different ideas on what should be. It doesn't mean that we're always right, and that's why I think these kinds of hearings are good. And I picked up some things that I thought were correct from the ACLU. I'll admit to that.
Mr. Chairman.
You're just rascals, I think.
Thank you, Mr. Chairman.
I would like to
Mr.
just,
Boswell?
I met Congressman Reyes in the hallway, and I came in. He was going to the Veterans Committee and was coming back. Just like to put in the record that he could submit questions, if that's okay.
Oh, yes, and members, if you would be available for questions for the record, some members want to have questions and weren't here, or they have additional questions. But I'd like to thank each of the panel members. It's been informative. I like the tenure of the questions from the panel, and Godspeed.
Thank you, Congressman.
Thank you.
Stuff in the tarmac this morning. I just fell out of the gym.